a pledge first, and then we can sit down and I'll explain what's happening. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Amen.
So a couple of things happened. The firehouse projector that's up above and it's hardwired. It's not working, so they left me this projector. That's fine. We got that going. But there's some technical issues there that have to be sorted through. What's happened now is I have a couple of videos I want to show you during the talk tonight, and I don't have other microphones or speakers, so it'll be a little difficult for you to hear. So I was trying to get that thing going, and that's what Norman is working on right now. It works, and then it just stops by itself. So if we can get it going, good, and if we can't, we'll figure it out. If I have to, I'll turn the computer around and hold it up, whatever. Welcome to We the People of Cape Cod Incorporated. For those of you who are online,
Testing 1, 2, 3.
yeah, pay no attention to that man behind the curtain. All right, don't worry about it. Just turn it off. Thank you. All right, so we're not going to have these speakers, but that's all right. For those of you who are just joining us online, we're a nonprofit, a 501c3 educational organization. We learn about and teach about the Constitution and try to spread the word of the U.S. Constitution, because I know we have a group of people from the UK watching us tonight, so let me be specific about that. One or two quick announcements. It's coming to the end of a 2-year period, and by the bylaws, we have to change our board. So if you think you would be interested and volunteer to serve on the board, would you please just, you know what, I'm going to leave this over here, and just sometime during the evening, come and put your name down. Doesn't take all that much time. And actually, this is a good opportunity for me to thank the current board members, who are Sylvia and Dot and Pam and Diane, and who am I leaving out here? Mike. And Mike. So I think a hand is deserved. All right, so are there any questions before I get rolling here? All right, so I try to pick timely topics. We're teaching about the Constitution. We have to put everything in the context of the Constitution. But I like to try to pick some hot button items. Of course, what's the big story at the moment? That's the nomination battle, and actually it's an epic battle over the nomination of Judge Brett Kavanaugh, the nomination to be a justice of the U.S. Supreme Court. So I thought that I would cover some of the protocols and the laws and the history of Supreme Court nominations. There's a little bit of red meat to be had, and I'm not ashamed of it, because it's very unusual times, as you all know. So that's tonight's talk: the Supreme Court battle, the laws, protocols, the history of staffing our court's highest land. If there's any new faces here, you all know to just raise your hand or ask a question at any time during. You don't have to wait until the end. So, what's in the Constitution? First of all, the Supreme Court is taken care of in a couple of spots in the Constitution. Of course, in Article 3, which deals with the judiciary. And can you see that okay, or do we need to put out more of the lights? You're okay? Oh, yeah. Okay, that's because this projector isn't as bright as the other one. Let's leave one on, Pam, okay? Because we're also videoing for the people who are. Yeah, that's good. Yeah. Right. So, Article 3, Section 1 of the Constitution.
Oh, that's good.
And I know I have a pointer, but I'm just going to use my hand tonight because we're already behind with all the other stuff that's going on. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordained and established, and it continues the judges and so on and so forth. Of course, at this point, they were referred to as judges. Not until a little bit later are they called justices. But this is Article 3, Section 1. Now, of course, Article 3 deals with other issues about the Supreme Court, issues of jurisdiction, not only geographic jurisdiction, but jurisdiction on the types of cases that fall under the jurisdiction of the Supreme Court. But there's also more about the Supreme Court in the Constitution, and that's under Article 2, which deals with the executive branch. And that's talking about the president. It says he shall have the power, bind with the advice and consent of the Senate, to make treaties, and shall nominate, blah, 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 and appoint ambassadors, other public ministers, counsels, judges of the Supreme Court, and so on and so forth. So there's more in the original articles of the Constitution dealing with the Supreme Court, but really, most of the details about the Supreme Court come a little bit later. The federal court system was established by the Judiciary Act of 1789, and that's what deals with some of the details I'll point out in a moment. But this fellow over here, Oliver Ellsworth, how many people have heard of Oliver Ellsworth? Just a couple or a few of you, and I guarantee you that in the general population, it would be even less. Oliver Ellsworth was on the Committee of Five that helped to draft the U.S. Constitution. He is a signer. He was a judge, of course, an attorney. Before that, he was a senator from Connecticut. And when the Judiciary Act of 1789 was being conceived, he was asked to be on a committee of 10 people to draft it. And he was the chairman of that committee. So, by the way, he was also the third Chief Justice of the U.S. Supreme Court. So Oliver Ellsworth is a name to remember. What did the Judiciary Act of 1789 do? Well, first of all, it authorized 13 federal court districts and addressed issues of jurisdiction. Again, not just geographic jurisdiction, but jurisdiction on what types of cases would be allotted to the Supreme Court and to the other courts. It established the Office of Attorney General, and it assigned a U.S. Marshal and a U.S. Attorney to each of the jurisdictions, I mean to each of the districts. And it authorized 6 Supreme Court justices, and this is the first time I saw it referred to as justices, was in this Judiciary Act. 1 Chief Justice and 5 Associate Justices. So my first comment on that is, remember about a year and a half ago when there were only 8 justices and there was all this hand-wringing and hair-pulling out about, oh, but we have an even number, what are we going to do? Well, the original Judiciary Act of 1789 actually gave us an even number of justices, and it worked okay. And it also determined that there should be 2 sessions each year for the Supreme Court, and other details, but we're not going to go into all of them right now. Because what I'm interested in mostly is, let me see if I can find the pointer over here. That would be nice. Yes, I've got it. What I'm interested in here is the actual appointment and the staffing of the Supreme Court. So those are the key items in the Judiciary Act of 1789. So how did we get to 9? What determined the changes in the number of justices? Lots of politics, I can tell you that right now, throughout. Some of it, what's that?
Expansion of the country.
Yeah, some of it was just expansion and redistricting around the country, but a lot of it was politics. So again, we started out with 6 justices in the Judiciary Act of 1789. Here's an interesting one, the Judiciary Act of 1801. Now this is when John Adams was president and he was getting ready to leave office. There were some issues that needed to be dealt with in the district courts, the circuit courts, and the Supreme Court. One of them was that the Supreme Court justices actually had a ride circuit, meaning that they had to go out and hear cases associated with all of the district courts on a periodic basis. And that was quite a burden on them. They didn't like that. So that needed to be fixed. And one thing the Judiciary Act of 1801 did was it reorganized and expanded the number of district courts and the number of circuit courts. Now, It also aimed to reduce the number of justices to 5. That is, when the next vacancy came, they were not going to fill it and leave it at 5. Lots of politics involved in this. So first of all, I love John Adams, but what he was doing was creating a whole lot more federal courts in the country that he could staff. And it led to a term that is known as the midnight judges. The midnight judges, because he was on his way out the door, and in a matter of weeks, he created all these new districts and circuits and was just jamming through Federalists. Now, who was coming into office after him was Thomas Jefferson, more on the anti-federalist side. And so when Thomas Jefferson got into office, the Judiciary Act of 1802 was enacted, and that essentially repealed the Judiciary Act of 1801. It did leave in some of the, the increased number of circuits and the increased number of districts. So it did partially solve some of the problems that they were facing, but it returned the number of justices to 6. Nobody had resigned in that short period of time, and the Judiciary Act of 1802 restored the number to 6. Then we had the then we had the Seventh Circuit Act of 1807. That was another big reorganization of the circuit court system. It added 1 Supreme Court justice, and let's see, we have another interesting one coming up. Yeah, in 1837, the Judiciary Act increased the number of justices to 9. Doesn't stay there. That's what it is now, but that's not exactly how we got there. In 1863, it was increased to 10. In 1866, they aimed to reduce the number to 7, again by retirement. And there was 1 retirement, but there were not 2 others. Now, what this was all about, this was the first Congress after the Civil War. And the Northern Republicans wanted to sap some of the power from the southern part of the country. There was something like 5 of the circuit courts were in the South, or in slaveholding states or slaveholding sympathizing states. And so Congress wanted to pull some of the judiciary weight away from the South. And so they aimed to reduce the number to 7, and they also redistricted and pushed some of those districts out of the South. Finally, the Judiciary Act of 1869, that set the number at 9, and that's what we're operating under to this day. However, hold your breath, because with the appointment or the nomination of 1 and the appointment of another, soon to be 2, justices in the Supreme Court by the current president, there's already talk being floated by, what do they call themselves, the resistance, that if and when they should return to a position of power and leverage, that they will significantly increase the number of Supreme Court justices, as our friend FDR attempted to do back in the 1930s, essentially to stack the court and rebalance it towards their favor. I don't think it's going to happen, but it'll be interesting current events as things unfold. Okay, so just a couple more facts and figures. Over all of our years, there's only been 113 Supreme Court justice successful appointments, confirmations, justices. So really, that's only roughly 2.5 per president. Some presidents didn't get to appoint any. I think Jimmy Carter most recently didn't get a single appointment, and some presidents got to appoint considerably more than that. Ronald Reagan, I think, had 4 or something like that. So there's only been 113, and the average time on the Supreme Court has been 15 years. But since the 1970s, that average has increased greatly, and it's probably due to a couple of things. It's probably due to our prolonged lifespan, but it's probably, as you'll see in a little bit, probably also due to the extreme partisanship that's developed in the past 50 years. And I'll show you a little graph that I put together to just demonstrate the kind of thing I'm talking about. Yeah, question?
Do we know anything about that the ages that we appoint is dropping, so they?
It is.
Okay.
Well, no. I take that back. I was going to say
Are they
yes,
appointed
because
older?
I know that in the past 20 years, the age has dropped considerably,
Okay.
especially in the past 10 years.
Okay,
However, I don't know if I can stretch that all the way back to the 18th century and the 19th century because the lifespan was so much shorter. They might have been appointed at the same age. Don't know the answer in short.
okay, thank you.
Okay, so what are the steps to get a justice appointed to the Supreme Court? Most of the people in this room, I bet all of the people in this room know it fairly well. I'm probably going to touch on one or two points that may be a little bit surprising to you or touch upon current events. All right, a vacancy is created, first of all, you need a vacancy, created in one of four ways. And actually, I should say there's more ways because we've seen historically that some administrations have sought to increase the size of the court. So I guess that's another way to create a vacancy. But these days, there's four ways to create a vacancy. One is impeachment, and one example of that is Samuel Chase, who was actually caught up in the politics surrounding the Judiciary Act of 1801 and the Act of 1802. I'll come back to that a little bit later on. Samuel Chase was impeached, but he was acquitted. So he served out his term on the Supreme Court. Abe Fortas in the 1960s was not impeached, but he did resign because he was under the dire threat of impeachment. Abe Fortas was appointed to the Supreme Court by Lyndon Johnson, and Lyndon Johnson was going to promote him to be the Chief Justice. But his past started catching up. And Abe Fortas was, just in a word, a crook. You know, he was doing favors in exchange for, more favors. How else? Retirement. Okay, well, the most recent example of that, of course, is Justice Kennedy, who just retired a couple of months ago. And we've had others in our lifetimes. But it's an interesting little point that retired justices, we immediately think of them as stepping aside and disappearing, into the sunset, but they can, and a number have served on other courts, circuit courts, federal courts around the country. Death. 35 justices have died while serving in office, and of course, the most recent was Antonin Scalia. That's who, as we all know in this room, Neil Gorsuch replaced. And then there's one of the category that I kind of created. It's called withering away or melting. And I think that's what we have right now. It's a political matter. I say it may require a girl with blue gingham dress and pigtails to throw a bucket of water on that particular Supreme Court justice. I'm going to come back to that one later because you're going to see some remarkable things about Justice, I call her Darth Vader Ginsburg, who is now 85 years old. And I can tell you something, I don't know how justices in their 70s carry that weight. But when you get to be 80 or so, it's even more difficult. And you're going to see by what I show you later, she's not doing it, right? So we're just going to have to wait for her to crumble and blow away. The steps, right? So the initial step is that the president will develop a short list, and then with the assistance of the some within the administration, and he could also outsource. Presidents have always outsourced for input on their Supreme Court potential nominees. They'll use the Bar Association. They will even consult the ACLU. In this particular case, we know that the current president consulted the Federalist Society and other attorneys and judges outside of those groups. The FBI conducts criminal background checks, and other offices in the Justice Department conduct personal checks like credit and other issues about security. And depending on which nominee or which president you are, they may subpoena your personal Netflix rental records, which occurred with Robert Bork back in the 70s, but I'm sorry, that was the early 80s. Right. Next, the president sends written notice to the Senate and informs the public. So let's follow along with the case that we're facing right now. That happened several weeks ago. And then what happens is that the Senate Judiciary Committee, actually, this is an interesting tidbit I stuck in here in the middle before I go on to the next slide. So from the time there's a vacancy to the time the president makes known his nominee, or her nominee, as the case may be someday, it can vary greatly. And I just thought this was very interesting. With the current president, he made his announcement, I think it was within about a week or 10 days. And some people were screeching that that was too fast. What's the big rush? Well, it turns out that it varies greatly. And by president, I'm looking at Bill Clinton over here, and for Justice Ginsburg, it was 87 days between the vacancy, the arrival of the vacancy, and his announcement about who his nominee would be, and 37 days when he nominated Justice Breyer. Under President Obama, it was about a month for both of his appointments. And under Ford, 16 days. Under Reagan, we had this one. Under the other Reagan ones, they were like, the vacancy opened and the announcement was made. And under George H.W. Bush, who had 2 appointments, 3 and 4 days, and under George W. Bush, 2 days. So it varies greatly. And I guess it's just a matter of who is prepared and has some forethought about an important topic like this. I'm not going to say anything else about who took the longest and who took the shortest. Let's get back to that other slide I was looking at. So then a series of informal meetings between the nominee and the senators take place, and that's at the same time that the nominations referred to the Senate Judiciary Committee for investigation and for hearings, and eventually for a vote on whether to refer the nomination to the full Senate. And this is about where we are right now in Judge Kavanaugh's nomination process. So we saw the hearings took place last week between Monday and Friday. These are the Senate Judiciary Committee hearings. And then the committee has to take a vote whether or not to pass that nomination on to the full Senate. The vote was taken in the past few days. It was 11-10, strictly along party lines. So his nomination will be passed on to the full Senate. The minority is allowed to ask for an 8-day delay before that decision is passed on and it's passed to the full Senate. And guess what? There's going to be an 8-day delay. So next week, there will be, that'll be formalized, and debate will begin in the Senate. Now, once debate begins in the full Senate.
Question.
Yeah.
There is nothing in the Constitution that lays all this out.
That's correct.
Theoretically, you can just nominate and have a vote.
That's correct. This is all laid out by various judiciary acts and also by Senate rules. So, and as you'll see in a little bit, well, I guess they're based in Senate rules, some protocols and traditions that are based in Senate rules and Senate rule changes. So a full Senate review and debate is right now on the slate, okay? At present, the Senate rules say that there can be 30 hours of debate on the nominee, and then they have to have a vote. However, there is a rules change that's being considered at this moment, which may or may not take place, which would limit that debate to 8 hours and not 30 hours. And we won't know about that for a few days. Okay, here's what I'm going to talk a little bit about the insane partisanship that's come into being. And, you know, I wish for the good old days, the way we were in some ways, okay? And yeah, that tune's running through my head as I made this slide. So look at this. From the Civil War. Now, it was a very different system, and the two parties that exist today did not exist before the Civil War. So I didn't look into that. And I didn't look into the time immediately after the Civil War because there was brutal partisanship right after that. But from one of the first nominations until 50 years ago, that window of time, so from about 1868 to 50 years ago, 1968, right? Justices were confirmed by acclamation 38 times. What does that mean for you who don't know? It's the the motion is made for a vote on the Senate floor, and everybody goes, bully, bully, and they're affirmed. It's just like a voice vote, all right? So 38 justices were approved by acclamation up until 50 years ago. In that window from 1968 to now, 0. All right, maybe we're getting a little bit more discriminating and responsible, right? Maybe. Let's break that 50 years down into the first 30 years and the last 20 years. The average vote to confirm was 89%. So whether you had a Republican, and I looked at these numbers, they were pretty close between Republicans and Democrats, who was the president and making the nomination, whether the Senate was controlled by Republicans and Democrats. From 1968 to 1998, almost 90%, I'm sorry,
89.
all of the Supreme Court justices were confirmed by an average vote of almost 90%, okay? The president made a nomination, the Senate is there for advice and consent, the president gets his nomination. Right? A couple of exceptions to that one. Look at this, in the past 20 years, we've dropped to 64%. And as you all well know, that's about to drop a little bit more in the coming weeks, because we're going to get about 54% of the Senate to make this vote. This is a little graph I put together just to make a visual of what I just said. So each of these represents a confirmation, and this is the year on the x-axis from 1965, really 1968, to 2018, and this is the percentage of the Senate that voted to confirm. And you can see, we go up over here, a lot of these are Ronald Reagan's. He got 100% in a number of cases, except for Bork, who we'll discuss later. This does not count the handful of justices who either withdrew or were rejected, or whom the president withdrew. So look at this. I mean, there's a couple of exceptions down here, but the bottom line is it's just gone down abysmally. It's turned into a real horrible battle in the past 20 years. All right, so one of the terms that you hear a lot, have heard a lot, particularly in the past 2 Supreme Court nominations from Neil Gorsuch and Brett Kavanaugh, is the thing called the blue slip courtesy. How many people in the room know, well, how many people have heard of the blue slip courtesy? Okay, I'm sure a number of you actually did, maybe by that name, but here's what it is. And those are the 2 premises, although I don't believe them. So let me tell you what it is. If a Supreme Court nominee is from Michigan, the 2 senators from Michigan will be accorded a specific privilege. They're sent out a little form on a blue piece of paper, and then they will return it, either supporting the nominee, or they won't return it, or rejecting the nominee. And some weight has been given to that. But there's history to the blue slip courtesy. It's called a courtesy for a reason, okay? Now, the reasons that it was established, and I'll tell you how and when and who in a moment, it was premised on the idea that home state senators are in a good position to know more about the nominee, right? And the second thing was it's supposed to, encourage consultation between the president and those home state senators. Is there anybody who really believes that crap all along? Because I don't. There's no goodwill in this process, and there never was. Okay, so but those are the premises that were laid out. Now, this is taken from a report by the current Senate Judiciary Committee Chairman Chuck Grassley to the Senate. And so it tells a little bit, there's more to this, and I've summarized it. It tells a little bit about the history of the blue slip courtesy, because what has happened, there have been a few cases in these, particularly in these past 2 nominations, where there happens to be a Democratic senator, I'll just say a senator from the opposition party in that blue state. So from the position, the party that's in opposition to the president. In this case, that's Democrats, okay? And they got to thinking, as the resistance does, that if they don't return their blue slip, or if they reject, that the nomination can't go forward. Okay? And there were times in history when that was true. But this tells a little bit about the history. So over the past 100 years, there have been 18 chairmen of the Senate Judiciary Committee. Only 2 of them required a positive blue slip from the nominees' home state senators. Only 2. So what you've been hearing lately about, oh, Senator so-and-so from the nominee's home state rejects him or hasn't returned the blue slip, so we can't go forward. Malarkey. Okay? That wasn't the original intention. And in fact, when it was created 100 years ago by the then Senate Judiciary Committee Chairman Charles Culberson, who was a Democrat, he started the blue slip practice just 101 years ago. And he did not require that both senators from that home state send in a positive blue slip. As a matter of fact, in that first year, when the blue slip courtesy was extended, Culberson held a hearing and a vote for a nominee who received a negative blue slip. So it was never a hard and fast rule. It was never intended to be a hard and fast rule. And over the vast majority of the history of the blue slip courtesy, it has not been a hard and fast rule that both senators from the home state had to return a positive blue slip. In fact, let's see. Yeah, we got more on the filibuster coming up. Here's more on the blue slip courtesy. So a couple of times it's changed. The first time was in 1956 by Chairman James Eastland, who was a Democrat from Mississippi. Was there politics involved in this? Was there politics involved in this? Well, of course there was. So again, from the time of Culberson up until 1956, it didn't require 2 positive blue slips to be returned by the home state senators. But Chairman Eastland changed it. Why? Well, he was a senator from Mississippi. He was against the integration and the other civil rights activities that were taking place at that time, particularly Brown versus the Board of Education. And he wanted to block particularly any Southern senators from going against his will. And so he made it necessary that there be 2 positive blue slips. For the 20-something years that he was the chairman of the Senate Judiciary Committee, that's how it was. However, it was changed by, of all people, another Democrat, Senator Ted Kennedy, who returned it largely to its original intent. That was followed by Senator Strom Thurmond, a Republican, formerly a Democrat, by Senator Joe Biden, yes, that Joe Biden, and by Orrin Hatch, a Republican. They've all followed the original intent of the blue slip courtesy from 1917. So it's only been Chairman Leahy, actually the second time, under President Obama, briefly changed the blue slip courtesy back to an essential, you have to submit 2 positives. That lasted for about a year, and then Chairman Grassley returned it to its original intent as well. So that's where we stand today. No politics involved in this. It's really respect for the Constitution that we're talking about. Okay, the other tool that you hear a lot about, and this is a really interesting, entertaining, and important element in this whole process, and that's the filibuster. So this is the etymology. This is the history of the word. Do not ask me to pronounce that word. I think it would be freebooter. And filibustero in Spanish. The original form of the word is supposed to come from the Dutch, freebooter. I really have trouble believing. I mean, after seeing what I saw in science and what I now see in politics, I have trouble believing anything. All right. But so when you go to Wikipedia and you see something, you always have to doubt it. This was meant to be like swashbuckling freebooter was the original meaning of these Dutch and Spanish words. And I don't see the direct translation into what a filibuster is. But anyway, that's what we're told the original derivation of the word is. So the first known use was in the time of Rome by Cato the Younger. Now, Julius Caesar was, this is going to be a little tough for me to remember. Julius Caesar was returning from battle. He was a war hero. And he was going to be given a Roman triumph, which is a big ceremony for a hero, and bestowed upon him a variety of glories. Okay, but he also wanted to run for consul, which was amongst the highest political positions in Rome. Now let me see if I get this right. The trouble is, you couldn't return to Rome and then get your triumph. You had to be welcomed into the city. Anybody see Ben-Hur? Where Ben-Hur rolls into the city after coming back? Well, actually, it's his benefactor that leads him back into the city and is awarded a triumph. You can't come back to the city and then, you know, at some later date get your triumph. You have to be greeted and brought into the city and awarded the triumph. Now, on the other hand, he couldn't run for consul if he came back into the city. So Cato the Younger filibustered to screw over Julius Caesar so that he couldn't get the consulship. Then again, in 59 BC, he filibustered Julius Caesar. There was a land reform that needed to be done, or that they wanted to do, and there was going to be a transfer of tracts of land, I assume to a buddy of Julius Caesar's, and Cato the Younger put on the filibuster. Now, what was Julius Caesar to do? Well, he arrested him. He was later let out because there was still some semblance of what they called democracy back then running the show. So Cato the Younger was released. He didn't rot away in the bowels of some prison. That's the first known use of a filibuster. In the United States, it was made possible by changes in the Senate rules in 1807. Proceedings were taking too long, and they decided that they needed to get a cap on how long senators could speak. Now, in the House of Representatives, the filibuster was killed. Well, it wasn't really a filibuster. The ability to speak endlessly was killed in 1842 by a change in House rules. So the House, with 435 members now, but many more members than the Senate, the House was more conscious of how its time was being used and spent. And so they put limits on how long speakers could continue on. More changes to the Senate rule in 1917 and 75 affected cloture. Now, I know that many of you have heard the term cloture, but just to define it, cloture is a vote to end a filibuster. It's a vote to shut somebody up, okay? So in 1917, cloture was made, the change in the Senate rules was made in 1917, and it required a 2/3 vote of the Senate. So if you were blabbing and blabbing and blabbing, somebody could call for cloture, you have a vote. If you can get 2/3 of the Senate to vote for you, that person has to sit down. In 1975, that number was reduced to a 3/5 majority, and that's where we stand today. Now that's important, of course, because that means for anything that gets done in the Senate, for anything that gets done, you, for all intents and purposes, have to have 60 votes, not 51, right? Because anybody can choose to filibuster, and before you can move on to the motion, you have to kill that filibuster. Now, changes in 2013 and 2017 have left the minority party with little power. In the process of judicial confirmations. And we're going to go into that in a little bit more detail later. Basically, they applied what was called the nuclear option. Now, people who are advocates of changing these Senate rules are known as, call it the constitutional option. I'm not sure it's constitutional one way or the other. And people who like, sensationalism call it the nuclear option. And we can thank Harry Reid, as we'll show a little bit later. I have some video for opening Pandora's box on this, because the filibuster was unassailable until recently. But during President Obama's presidency, the Republicans were putting on the skids about confirming his appointments both in the federal government and also in the judiciary. I should say in the judiciary and in other areas of the federal government. And so he ended the filibuster for judicial nominations and other nominations, except for the Supreme Court. How's that done? Well, there was just an accounting for how it was done, because now, as you can imagine, there's a lot more scrutiny applied than there was in 2013 when it was done. And here's what Mitch McConnell just did recently. Now, I must say, I understand these steps. It makes me think a little bit that this is all a phony process again. Because what you have to do is, you see, you can't just change the Senate, you can't just change the rules on a filibuster by saying, I want to change the Senate rules and, end the filibuster. Because even that is subject to a filibuster. Right? So what you have to do is you have to set in motion some things that must play out and that require only a simple majority vote. And these are the steps that both Harry Reid used when he was Senate Judiciary Committee Chairman, and this is what Mitch McConnell just did recently. So you have a vote for cloture. In this particular case today, the Republicans have 51 or 52, depending on what month you're talking about, senators. So they have a majority, but they do not have what's called a supermajority, 60 votes to effect a cloture. So there's a vote on cloture. It fails, and then a motion is made to reconsider that vote. You could do that at any time. You could do that in town meeting. This motion can't be debated, and it requires a simple majority to pass. These are just Senate rules. Then a point of order is raised. So again, just like town meeting, you could raise your hand and say, point of order, Mr. Moderator, I think we're doing this wrong, whatever, it should be done this way and that way. A point of order is raised to contest that vote. And then the chair rules against the point of order because it violates the Senate rules. So the point of order is just somebody raises out, Mr. Chairman, I object. I think we're doing things wrong. 51 votes is required for cloture, which of course is wrong. And the chairman points this out and rules against the point of order because it violates Senate rules. Well, then an appeal is made to overrule the chairman's decision. Now, a vote is taken to overrule the chairman, and that only requires a minority. So you see what you're doing here. You're just using a simple majority to change a ruling that overruled the point of order. I can't even keep up with it. You get the idea, okay? Now, it doesn't end there, because there's going to be another internal loop to this whole thing. An appeal, in this case, will be made by the minority party, and you're going to go back 3 steps and have to, the minority party will raise a point of order and challenge the chairman, and you'll have to go through those 2 subsequent steps again. But if you're in the minority party, you're going to lose the ultimate vote. So ultimately, so where were we here? So the chair rules against the vote. So an appeal is made to overrule the chair, a vote is taken, and this time the vote, the appeal is killed. So the previous appeal stands, and now you've gotten rid of the filibuster, or whatever the item that you stipulated were. Yeah, a new cloture vote requiring only a simple majority, and of course the minority party fails to pass that. All right, politics and folly. We could go on ad infinitum here, okay? So I'm just slapping up a few of these just to run through them in about 30 seconds. Attempts to manipulate the size of the Supreme Court. Well, John Adams did. Really, he wasn't focused so much on the Supreme Court as he was on the federal judiciary. And again, that's the midnight judges. Marbury, of Marbury versus Madison, was caught up in that. He was one of the, he wasn't a Supreme Court justice, but he was a justice of the peace that was caught up in that. And of course, that famous case. So John Adams attempted to manipulate the size of the judiciary. He wanted to pack as many Federalists into the judiciary as he could. Thomas Jefferson and his cohorts didn't want that, so hence the Act of 1802. By the way, I'll go back to that that impeachment we were talking about before. I'm blocking on his name. Charles Chase, was that it?
Samuel Chase.
Samuel Chase, yeah. What happened was he was one of the appointments early on, and when Jefferson was fighting to repeal the Act of 1801, Chase came out publicly and chastised Jefferson and Jefferson's supporters, their political position. And so in the case of revenge was true back then as it is today, the anti-federalists, the Democratic Republican Party, voted to voted to impeach Samuel Chase. But again, they didn't have the votes in the Senate, so he served out his term. Of course, Franklin Roosevelt, we talked about his attempts to pack the Supreme Court on a couple of earlier occasions in this class. He wasn't during his promotion of the New Deal. Some of these things were being challenged in the courts. The Supreme Court was rejecting some of their proposals, saying they were unconstitutional. And so Franklin Roosevelt's answer to that was to attack the Supreme Court, saying they're a bunch of old farts, a bunch of old men, and that they need to retire at 75. And if they don't retire at 75, to do them a favor, what we're going to do is we're going to appoint an associate justice that will kind of help them out, up to 6 of them to help, the oldest 6 in the court. But of course, they would have a full vote on the Supreme Court. So he was trying to pack the court with his own appointees by increasing the number of Supreme Court justices to 15. And as you know, as we've discussed earlier, that never happened. It was just a total screw up. It met with a great public outcry. Congress and even some of FDR's allies in Congress and in government pulled their support from the whole idea, and it just died and was left by the wayside. Here, attempts to smear nominees into oblivion. Well, it's happened a bunch of times, but in our lifetimes, Robert Bork is probably the most famous, and that's what comes, that's when your name gets turned into a verb. You've heard the expression to be borked. Okay, yeah.
Just a brief thing that perhaps many folks here have heard. Within the past hour and a half, it was reported that Senator Feinstein received a letter from a Democratic representative from California. The letter purports to show that the president's nominee, Brett Kavanaugh, while in high school, it had to be 35 years ago, somehow sexually molested or whatever. That's more of the same Ted Kennedy type.
Right. I heard that on the radio on the way here, but they didn't give any details. It was a very poor report. They just said that Dianne Feinstein had turned over a letter regarding Kavanaugh to the Justice Department.
He turned the evidence over to the FBI, who put it in his file, but it's certainly not going to make the fireworks next week less.
It's not going to change anything.
It said the letter came to her in the summer. Well, it's essentially it's still summer, but it sounded like the heat of the summer.
Right. So, Judge Bork, of course, was highly qualified to serve. He was a judge in one of the most important circuit courts of appeals, the Washington D.C. Circuit Court of Appeals. He served as the Solicitor General. He even, for a short period, served as the acting Attorney General. He was an originalist, an outspoken originalist, but his time as the acting Attorney General was what really brought the ire of the opposition upon him, because that was under Richard Nixon. And Richard Nixon wanted the Attorney General to fire special counsel. The Attorney General would not, he resigned. The Assistant Attorney General would not, he resigned. Bork came up through the ranks, and Bork did fire the Attorney General, the special prosecutor. So the ire of the opposition was brought upon him, and he was just totally smeared. And of course, Clarence Thomas was speared in what he, I think, rightful, well, I'm not even going to get into it, but, over sexual harassment charges by Anita Hill. None of it ever bore out. It's just more of the same trash. The politics of personal destruction are just disgusting. I think we finally reached a point where it's not going to make any difference. I'll make a prediction about what's going to happen. in a little while. And then, of course, attempts to halt the proceedings altogether. Well, President Obama nominated Merrick Garland. We're going to talk more about this in a moment, in the next slide or two. And these proceedings were held up altogether. I'll talk in more detail about how or why, but that's the successful one. And of course, both of President Trump's nominees, nominations, both Neil Gorsuch and Brett Kavanaugh, as you can see, we're trying to drag it out every possible way we can and try to derail the process. But here we go. Now let's talk in specifics about some of these. And here's where I wish I had that microphone, because I have some video to show you, people in their own words. And I'm going to hope you can hear it if I crank up my computer at full volume. The Biden rule and McConnell's revenge is the first modern case of folly in politics that deserves mention here, I think. So what was the Biden rule? What was McConnell's revenge? Well, in 1992, then Senate Judiciary Committee Chairman Joe Biden, yes, that Joe Biden, got up before the Senate and made a speech in which he said that there should not be a nominee to the Supreme Court in the year before an election or in the year of an election, because, let me play this for you, and I hope you can hear it.
The C-SPAN networks bring you long-form public
You're not going to be able to hear it.
relations capital and the Republic service of your television provider. C-SPAN, created by cable.
I'll try to.
As a result,
Oh, can you hear it?
it is my view that if a Supreme Court justice resigns tomorrow or within the next several weeks, or resigns at the end of the summer, President Bush should consider following the practice of a majority of his predecessors and not name a nominee until after the November election is completed. The Senate, too, Mr. President, must consider how it would respond to a Supreme Court vacancy that would occur in the full throes of an election year. It is my view that if the President goes the way of Presidents Fillmore and Johnson and presses an election year nomination, the Senate Judiciary Committee should seriously consider not scheduling confirmation hearings on the nomination until.
All right. So if you couldn't hear, in Joe Biden's own words, that the president should not make a nomination in his final year, and that if he does, that the Senate Judiciary Committee should not have a vote. They should hold it up. Well, of course, that's exactly what wily Mitch McConnell, the new Senate Judiciary Committee chairman did with Merrick. Now, there was, with Merrick Garland, there was no Senate rule, there was no real Biden rule, but he used Biden's own words against them. And so, clever and resourceful in ways that sometimes that party is not. More politics and folly. Harry Reid opens Pandora's box, and McConnell again gets revenge. And what I'm referring to here is in 2013, when President Obama's federal appointees were not being pushed to the Senate quickly enough, Harry Reid compromised the strength of the filibuster. He opened Pandora's box. The filibuster was unassailable. And Harry Reid changed the Senate rules in the manner I just told you about a little while ago. And now it's that slippery slope. So now again, wily Mitch McConnell was easily able to change the Senate rules again in 2017. Yeah, 17. To eliminate the filibuster for all judicial nominations. Can't hear that, can you? Well, what he's saying is that Congress should be passing laws to support American families and all this sort of stuff, not be wasting time on filibusters and debate like this. So it's in this speech that Harry Reid ends the requirement for cloture, essentially, for all federal court nominees except the Supreme Court. And last but not least, in the three cases I'll discuss, there's Darth Bader's ego. That would be Justice Ruth Bader Ginsburg. Why? What was she thinking? What was she thinking? She was 80 years old. 5 years ago, she discussed her retirement with her colleague, John Paul Stevens. She was going to retire. She considered she had a chance to vacate the seat for another non-constitutionalist in 2015. Now, we all know that there's politics involved in this, and what one might term a conservative or a liberal Supreme Court justice, we might term them as non-constitutionalists and originalists. They often try to wait until there's a president in office with similar convictions to their own before they retire, so that they'll be replaced by someone who's like-minded. And Justice Ginsburg had the opportunity to do that in 2015, but she still did not retire. Then she stated publicly just recently, as long as she can do the job full steam, she will not retire. Let me show you some pictures here. This is Justice Ginsburg here in the middle. This is at President Barack Obama's State of the Union speech, with her chin planted firmly on her chest, asleep. The second one over here, leaning over towards, I guess that's Kagan there, I can't tell from this angle, leaning over towards Kagan, sound asleep, is during the Pope's address in Washington, D.C. And here's the most egregious of all. This is during the hearing of oral arguments in a Supreme Court session. Now, the cameras and video is not allowed in there, but you've seen images like this plenty of times before of a court artist sketching the proceedings. And here she is with her head planted firmly on the bench while oral arguments are taking place. Now, these aren't just rare cases. This isn't the one case. I can even, I don't blame her for falling asleep during some of those things. But by her own admission, by conversation and interviews with other justices, she said usually she's sitting next to Sotomayor and Kagan, and they keep her awake. They'll nudge her. In this particular case over here, she says she was sitting between Kennedy, and I can't see who that is with this lighting. But who was it?
Breyer.
Yeah, Kennedy and maybe Breyer. And she thought that they might have felt a little bit too shy to give her an elbow. So here she is, falling asleep at the bench and counting on her colleagues to give her one of those to stay awake. But as long as she can perform the job full steam, she's going to stay in there. What drives a person like that? Is it ego? It's beyond politics. I mean, politics is what's keeping her in at the moment. But 5 and 7 years ago, it wasn't politics. It's something that she views as bigger than the Constitution. Finally, real folly, real politics, when the Constitution, protocol, decorum all mean absolutely nothing. How many of you watched the opening comments in the hearing of Judge Kavanaugh last week? I hope you can hear this. I think the volume is high enough. Let me just set it up for you. The Senate Judiciary Chairman, Chuck Grassley, makes the opening comments. He welcomes everybody. He introduces the nominee, and then he begins the business part of the proceedings. He hadn't opened his mouth for more than 5 seconds before a series of interruptions occurred that were totally out of order, that were gavelled down, but continued. Now, this video is actually about 20 minutes, but we're only going to watch a couple of minutes of it. You'll get the idea. And I think if you haven't seen this, you need to go search on YouTube so you can watch it close up and really hear it well. It's disgusting. It's disgusting. Oh. He's already been interrupted. Sorry, can't hear this. He's already been interrupted by Kamala Harris. Now, she's not gonna shut up. In the meanwhile, behind this, you can hear a call to order and a gavel banging. You can't hear it right now, I apologize. She doesn't shut up. She's told she's out of order. She finally shuts up, and then the next one interrupts.
She also called the Constitution that little book.
Yeah, right. And he's trying to say, I want to extend you all a warm welcome. He hasn't even started talking about anything. She's being called to order, the gavel is sounding, and it ain't happening.
Does she have any sense that this is at least out of protocol or before? I only caught a snippet of it.
Now we have Blumenthal interrupting and calling for it to adjourn. Now the screaming from the gallery begins. The police have to escort several people out. They should have been handcuffed and carried out. And this just goes on. Next is Cory Booker. Next is the idiot from Hawaii. And it just goes on and on and on. There's no decorum, no
She
protocol.
thinks she is creating a video clip for her presidential campaign.
Yes,
So as far as she's
Yeah.
concerned,
Yeah.
this clip is to her advantage.
and she is creating a video clip for her presidential campaign that the Republicans will use.
Yeah.
I don't know if any of you have seen the video the online advertisement Crazy Town that the Republicans have recently put out. And it's just all this kind of stuff. Will it sink in on the American people? We don't know the answer to that. I'd be happy to discuss that with you after this presentation is over, because it's another issue altogether. Yes, Norman?
All those people up there were screaming and everything else.
Yes,
There's a rule that's been in since the 1800s. You have to get a ticket to go up there. And 90% are all signed by Chuck Schumer.
yes.
You planted those people up there.
Oh, I heard Warren had a hand in any on some of those passes.
There were also reports of people receiving cash payments while online, going into the gallery. So, look, I don't often do this, but it's getting really to the nitty-gritty, both with our Supreme Court and with our Congress and with our country. And so when elections are coming around, I tend to take time to do some analysis. Now, I'm not one to toot my own horn, but in 2014, I was exactly on the mark and projected that the Republicans would pick up 9 seats, and exactly which ones. In 2016, those of you who heard me on the campaign trail know that I told you Donald Trump was going to win.
Right.
You knew that I told you that the pharmaceutical company stocks were going to skyrocket for the sale of antidepressants. And you also knew that I wish I took advantage of my own advice there and bought some of those stocks. Know that I told you that Trump was going to win the Republican nomination with more than 1,300, whatever the number was, clear. And that there was not going to be any open convention, that he would easily clear the number of delegates that he needed. And I'm going to make some predictions now. I can make some predictions about the November elections too, but that's not the subject of tonight's talk. But I can make some predictions. I was thinking about the Ghost of Christmas Future here when I made that slide.
Sure.
Feel free to mark my words, because it's good news for all. It's good news for the US Constitution. Here's what's going to happen. Take it to the bank, come back and yell at me if I'm wrong. I ain't. Kavanaugh will be confirmed in a 54-46 vote. Could be 55-45, so plus or minus 1. He will be confirmed, and he will be confirmed in time to sit for the October session, which means he'll likely be confirmed before September 30th.
Yeah.
That will happen.
So does that mean that Susan Collins will vote for him?
Oh, she's going to vote for him, yes, absolutely.
I think she already said.
Yeah, she said it was illegal.
She hasn't,
Oh, and the bullying that she's gotten up and made from the
that's
activists.
pissing her off.
That's pissing her off, and she knows her activists that are not going to be for her in November anyway.
I'm glad to see that she's got at least that principle to
Well, Susan Collins and those kinds of Republicans operate under the old rules. The old rules is unless the guy, robbed the bank, you voted for the Democrats nominee. And so they do the same for the Republicans nominee, and they don't go through this legal constitutionality through a fine-tooth comb.
Right. Right.
If Kavanaugh had said he was going to immediately shoot down Roe v. Wade, well, then you might have swung her.
Yeah.
But of course, he didn't say that.
And of course, he's shooting the bull when he, this, Susan Collins wanted to hear about existing precedent. But that's malarkey. We all know that's malarkey, because if we went only on precedent, then help me out with the Civil War case. The Dred Scott decision would
Dred
still
Scott would
stand.
be there. Plessy
Dred
v.
Scott would
Dirk,
still stand.
Ferguson would still be there.
Right. So precedent doesn't determine future. What determines a decision in the Supreme Court is the facts on the ground for that case. That's all. So, Susan Collins needed coverage and Brett Kavanaugh gave it to her by saying it's established precedent. It is. It is. But a lot of legal scholars believe it's very poor jurisprudence. So, item number two, Darth Vader will retire during President Trump's presidency. She cannot make it another 6.5 years. She will, if she wakes up, she'll get up and walk out and not come back one day. And President Trump will have another. Now, if you want to see the mud, I'm using a nice word, if you want to see the mud hit the fan, you see, because up until now, replacing Scalia has been replacing one originalist with another. Replacing Kennedy would be replacing one sometimes originalist with another. But replacing Ginsburg will be replacing a progressive with an originalist. And it will hit the fan. But there will be another appointment under this White House administration. That'll effectively give us a 6-3 Supreme Court, constitutionalists versus activists. The best is yet to come, because Stephen Breyer is also beyond retirement age, and he'll be the next. He's the second oldest on the court. He will not last another 6 years. Everybody knows that guys died before women anyway, right? You ever hear that one? Why do men die before their wives?
Because they can't.
Because they want to.
Oh, they want.
How old is Brian?
Breyer is going to be 80.
Oh my God.
He's 80. Yeah. Did I just say something politically incorrect? was that a Me Too moment? No, that was a Jackie Gleason moment. Yes.
About a year or so ago, there were rumors floating around about Clarence Thomas.
I'm getting to that.
You would think.
Okay, so when Breyer retires and is replaced during this administration, it will essentially give us a 7-2 Supreme Court of originalists, constitutionalists versus activists. And then last but not least, as you were pointing out, a couple of years ago, Clarence Thomas was talking about retiring. And this is a case like Ginsburg originally, or like so many other justices, he probably held off to wait and see what was going to happen in the 2016 election. Well, so don't be surprised if Justice Thomas, who I think is 70 now, if he retires, during the next 6 years, or maybe even during the next 2 years, and will be replaced by another Clarence Thomas, we hope. So I think that's it. That's all good news, folks. We have a couple of questions. I just want to make a final comment or two. That's all good news. The Supreme Court is coming around to becoming a constitutional court again, instead of a land for activist jubilees. And so you saw in this last session, every single decision, every one of the major decisions went against the non-constitutionalists. And they have and are going to have far-reaching consequences. So the Supreme Court is being restored. I'm grateful for it. It's easy to understand what's happening, and that's how it's going to be. So we have a couple of questions. Phyllis?
Okay, I know that during Reagan's administration, he appointed several justices, and we thought he's picked originalists, and they turned out to be non-originalists.
Always happens. I think David Souter was one of them.
Souter was one.
Well, Souter was like third choice, okay? They shot down.
They shot down Bork. They shot down
another Ginsburg.
Yeah, you're right.
Right?
You're right.
They got him on something like he smoked marijuana or something.
Wasn't Allen Ginsburg, was it?
No.
Okay, so but I've heard rumors now, and I've read a very good article that Kavanaugh is gonna be just like Kennedy. He clerked for Kennedy, and he's not gonna be the originalist you think he is.
Well, there's no way to tell until you see them in action on the Supreme Court. The only thing that we can go by is what their record on the current court they're serving on, or their past judicial record is.
He's got a big one.
Yeah, he's got a big one, and my understanding, although I haven't taken the time to look over his decisions, is that he's, well, first of all, he's been upheld by the Supreme Court. His positions, whether it was dissenting or voting in the majority, have been upheld by subsequent Supreme Court decisions. That there is at least an improvement over for instance, the California Ninth Circuit Court of Appeals. So you know something about his record you can comment on?
No, I think I would like Trump or any Republican president to be able to appoint one real fire-breathing libertarian constitutionalist. Reagan was able to appoint Scalia because it was before the battle started before. And then they were able to appoint Thomas because he was politically incorrect to vote against a black judge. And so that helped him across the finish line, where they attacked him ferociously. And Thomas didn't forget it when he got onto the bench. Now with Kavanaugh and Gorsuch, they appoint eminently qualified justices, but they're moderately constitutionalist, and they're not ferocious. They're always going to talk about precedent. I just like one fire breather because Scalia had more influence by writing dissenting judgments than most of those judges. These have an effect. And Scalia pushed the legal system to the right without winning the votes because he was such a convincing and such an authoritative thing. And the other thing is, and this is what saved it, this is why Trump, through no fault of his own, is going to be the most pro-constitutionalist president because he has these friends, and they're called the Federalist Society. Yeah. The Federalist Society, I mean, every Republican president has tried to appoint relatively conservative justices. What did Dwight Eisenhower, when he was asked, his biggest mistake was as president? Appointing Earl Warren. Yeah. But ever since the Federalist Society came in, I mean, Donald just took a list, okay, and checked one off. I think that's a sterling example of the right-wing reverse march to the institutions. It's using Gramsci against it, because the Federalist Society is a minority of in all the law schools, but they're more influential because they advise presidents who are elected by 50% of the public, or usually Republicans, right? And that's why we have the system that we have. That's why, given any reasonable amount of power, I mean, usually Republicans cannot win anything unless they have an overwhelming majority. Federalist Society allows Republicans to, 50.1% is enough for them to change jurisprudence in this, and which changes everything. But I have a question about you, is that once we have a constitutionalist court, the left is going to change its strategy.
Well, they're already talking about increasing the court size if they can get back.
Well, that's court packing, okay?
Yeah,
and court packing, unfortunately, has a precedent which they will have to.
Okay, finish your question because I think I know what you're going to ask.
Ever since the progressive era, the goal has been to create a living document constitution. Right. In other words, allow themselves to say what the Constitution means. Okay, make the Constitution say what they want it to mean. Once a genuinely constitutional judicial regime is in place, they will take the next step, which is to hell with their Constitution. Well, there'll be a full direct assault on the Constitution as it is.
The alternatives that they have pop into my mind right now, something that a strategy they're already attempting, which is to dominate the state attorney general's offices because they take everything to court. But ultimately, like all of this, just like all the delays in the Kavanaugh hearing, ultimately this is all a losing strategy, because they'll win some cases, but the important ones will make their way up to the Supreme Court and be beaten back. That's what's happening right now for the past year and a half, 2 years, is that everything is challenged. Everything is challenged. If the president has to go to the bathroom, they challenge whether or not he can flush. And so, but ultimately, he gets the flush. So, and thank God for that. So, the other thing that they can do is they can put on a push to modify or eliminate the Electoral College, which is nearly, it's impossible. It's impossible to get rid of the Electoral College and still have the United States of America. It was impossible to found the United States of America without that compromise, without that great compromise. And it will be impossible to hold the United States together. But also, it requires, a constitutional amendment, and that's just not going to happen because all of the states that the Electoral College is protecting, which make up something like 2/3 of the states, are never going to flip and vote the other way. So, meanwhile, the motion that they're using right now is this majority vote. I forget what they call it, where they give all their electoral votes to whoever wins the popular vote.
Yeah.
But that's only the states. It's only the coastal states anyway that are doing that. So what they're going to find is that on occasion, not often right now, but on occasion, they're going to wind up giving all their electoral votes to a Republican candidate. Because as with Reagan and some other past Republican presidents, occasionally the Republican will win some of those, what used to be called blue wall states. We saw that in 2016. Let me go to Norman, and then we have questions.
Yeah.
Push two then.
On this Kavanaugh person, there's one thing I feel uncomfortable with, and that he stressed this several times whenever he was allowed to speak, and that was his overly abundant reliance on precedent.
I don't believe it.
That's what he kept saying.
I think he was very careful. These hearings are such a fallacy. They're such a sham that, thank God, he and several others that have preceded him have been smart enough to tell the idiots what they want to hear and couch it in terms that don't make.
It's interesting you say what you say, because I was thinking that same thing.
And couch it in terms that don't make him a direct liar.
Yeah.
And it's about time that we started making an art of that, because it's used against us Americans all the time. There was a comment over.
Thanks for answering about the Electoral College. That was my first question. My second one is, what does the term advise and consent mean? Have we decided, has the Senate Judiciary Committee determined that that means more than it was intended to mean?
Well, it does say that the president shall appoint, or I don't remember what appoint was used, but he shall do it with the advice and consent of the Senate. So you could argue that advice is not a law. Advice is not, the final say. And consent can be construed as being a final say. But the bottom line is, since the word shall is used, it seems to me, I'm not an attorney, since the term shall A and B, then A and B are the law. So if the Senate does not consent, or in the case of Merrick Garland, when Obama nominated him and the Republicans had the Senate, they shall not even advise the president. So the Senate really does have the power to stop the process.
That they would not consent to him.
Well, they not only wouldn't they consent to him, but they wouldn't even render advice.
They wouldn't even bring it up.
Yeah, they wouldn't even render advice.
Okay,
So
thanks.
they wouldn't even have hearings. So I think the word shall.
Okay.
Another in the back.
Does the word shall have an imperative mood? That seems to be third person.
It's a mandatory term.
That's what Mike is saying. I can't answer that directly.
And also, where is it discussed the strategy of using the electoral
blocks by state. What you're saying.
You mean where is it used, where is
Well,
it,
you were discussing-
to subvert that, you mean?
Well, each state decides how it's
Well,
going to divide up
two
its
things. One,
electoral
you're
vote.
referring to a recent strategy that has come to election.
Right.
Where is that discussed?
You'd have to go on it. There's actually a name for the movement, and I forget what it's called. Does anybody know what the name for the movement is? Just Google some terms and
But it
it'll
has
come
to
up.
be done state by state.
It has to be done state by state, and there's a handful of states that have already decided they're gonna do it, but they've never had to do it.
But there has been, several ways in which states have apportioned electoral votes
Over the years.
Yes.
over the years.
I'm not sure if what they're, you see, I'm not sure if what they're doing would even meet a legal challenge. I think it hasn't been challenged because it's been irrelevant. It hasn't, there's been nobody can claim damages, nobody can claim standing at this point, I think, because it hasn't happened. So, you know, when it happens, it will be challenged and it will lose, especially if we have an original Supreme Court.
Well, it doesn't require, well, I'll have to check the Constitution. Does the Constitution specify how the electoral votes are to be apportioned?
Well, again, it says, if I recall the wording, we can get out the Constitution and look, but it says that the electors shall be assigned, you know,
According
but
to the
no,
population.
They were sometimes apportioned with 4 different ways.
yeah, so clearly there's wiggle room in that for more than one reason. Obviously, because states like Maine, who have 2 congressional districts, assign their electors differently for those 2 districts. And something else is
One
coming to
elector
mind.
for each.
One, let's see, how does it work? One goes according to the congressional district.
Oh, okay.
So I don't remember, but
No,
it's,
I think it's
and Nebraska's another one, I think.
the 2 Senate, the 2 votes that come from the Senate, they go by the majority
Of the state.
The whole state.
But the
and then
congressional districts,
And each congressional
Right,
district
this
is
two
the
congressional
majority in
districts.
that district.
Majority of that district.
See,
Right.
Chris, I think the problem is that in the early days of the Republic, there were a variety of ways of selecting
I'm gonna end the broadcast.
electors. But the problem is since then, under an extension of the